and compared all the evidence, cannot say that you are firmly convinced that the aggravating circumstance of which the defendant was found guilty outweighs the mitigating factors. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. The aggravating circumstance that you shall consider as to count 1 is: this offense was part of a course of conduct involving the purposeful killing of or attempt to kill 2 or more persons by the defendant. The aggravated murder itself is not an aggravating circumstance. You may only consider the aggravating circumstance that was just described to you and which accompanied the aggravated murder. Mitigating factors are factors about an individual or an offense that weigh in favor of a decision that a life sentence rather than a death sentence is appropriate. Mitigating factors are factors that diminish the appropriateness of a death sentence. You must consider all of the mitigating factors presented to you. Mitigating factors include, but are not limited to, the nature and circumstances of the offense, the history, character, and background of the defendant, and whether it is unlikely that the offense would have been committed but for the fact that the defendant was under duress, coercion, or strong provocation, whether the defendant suffered from post-traumatic stress disorder, or any other factors that weigh in favor of a sentence other than death. This means you are not limited to the specific mitigating factors that have been described to you. You should consider any other mitigating factors that weigh in favor of a sentence other than death. Any one of these mitigating factors standing alone is sufficient to support a sentence of life imprisonment if the aggravating circumstance is not sufficient to outweigh the mitigating factors beyond a reasonable doubt. Also, the cumulative effect of the mitigating factors will support a sentence of life imprisonment if the aggravating circumstance is not sufficient to outweigh the mitigating factors beyond a reasonable doubt. It is not necessary that the members of the jury unanimously agree on the existence of a mitigating factor before that factor can be weighed by any juror against the aggravating circumstance. Now, I used the phrase duress and coercion earlier, so I'm going to just define those terms for you. Duress means that the defendant was compelled to act either by actual physical force or threatened physical force directed toward him. Coercion means force or threat of force by another, urgent circumstances, or some combination of them, which overcame the mind or volition of the defendant so that he acted other than he would have acted in the absence of those influences. Whether a course of conduct placed the defendant under duress or coercion depends on the effect of the conduct upon the defendant, considering the defendant's age, sex, health, mental condition, and all the surrounding circumstances. The procedure that you must follow in arriving at your verdict in this phase of the trial is prescribed by law, and in this regard, you shall consider all of the testimony and evidence relating to the aggravating circumstance the defendant was found guilty of committing, and mitigating factors raised at both phases of the trial: the statement of Kenan Ivery, the psychological testimony, and the final arguments of counsel. You shall then decide whether the state of Ohio proved beyond a reasonable doubt that the aggravating circumstance outweighs the mitigating factors presented in this case. It is the quality of the evidence regarding aggravating circumstance and mitigating factors that must be given primary consideration by you. The quality of the evidence may or may not be the same as the quantity of the evidence, that is, the number of witnesses or exhibits presented in this case. If all 12 of you find that the state of Ohio proved beyond reasonable doubt that the aggravating circumstance the defendant was guilty of committing is sufficient to outweigh the mitigating factors in this case, then it will be your duty to decide that the sentence of death shall be imposed upon the defendant, Mr. Ivery. If you find that the state of Ohio has failed to prove beyond a reasonable doubt that the aggravating circumstance Kenan Ivery was guilty of committing is sufficient to outweigh the mitigating factors present in this case, then it will be your duty to decide which of the following life sentence alternatives should be imposed: the sentence of life imprisonment with no parole eligibility until 25 full years of imprisonment have been served, the sentence of life imprisonment with no parole eligibility until 30 full full years of imprisonment have been served, or life imprisonment without the possibility of parole. If the weight of the aggravating circumstance and mitigating factors are equal, then you must proceed to consider the life sentence alternatives. You are not required to unanimously find that the state failed to prove that the aggravating circumstance outweighs the mitigating factors before considering one of the life sentence alternatives. You should proceed to consider and choose one of the life sentence alternatives if any one or more of you conclude that the state has failed to prove beyond a reasonable doubt that the aggravating circumstance outweighs the mitigating factors. One juror may prevent a death penalty determination by finding that the aggravating circumstance does not outweigh the mitigating factors. You must be unanimous on one of the life sentence alternatives before you can render that verdict to the court. If you cannot unanimously agree on a specific life sentence, you will then inform the court by written note that you are unable to render a sentencing verdict. Now, the opening statements and final arguments of counsel are designed to assist you, but they are not evidence. Although the arguments of counsel are not evidence in this case, the law permits you to consider the arguments of counsel to the extent that they are relevant to the sentence that should be imposed upon the defendant, Kenan Ivery. Some of the evidence and testimony that you considered in the trial phase of this case may not be considered in this sentencing phase. For purposes of this proceeding, you are to consider only that evidence admitted in the trial phase that is relevant to the aggravating circumstance of which the defendant has been found guilty and to any of the mitigating factors. During the trial phase of this case, you received numerous exhibits. Not all of those exhibits are being submitted to you for your consideration during this sentencing phase. You may only consider the trial phase exhibits that were also submitted during the sentencing phase. You will also consider all of the evidence admitted during the sentencing phase together with the defendant's statement. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You may not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility or believability of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses, including the defendant. You will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, prior criminal record, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The statement of the defendant is to be weighed by the same rules that apply to other witnesses. Now, generally, a witness may not express an opinion. However, a person who follows a profession or special line of work may express his or her opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must decide whether the assumed facts upon which the expert based his or her opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. As with the other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In deciding its weight, you may take into consideration his or her skill, experience, knowledge, veracity or truthfulness, familiarity with the facts of the case, and the usual rules for testing credibility or believability and deciding the weight to be given to testimony. When you consider the nature and circumstances of the offense, you may only consider them if they have any mitigating value. You may not consider the nature and circumstances of the crime as an aggravating circumstance. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence and make your finding with intelligence and impartiality, without bias, sympathy, or prejudice. If, during the course of the trial, the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. We will now hear the closing arguments of counsel. The prosecutor goes first, defense then goes next, and the prosecutor may then give a brief rebuttal argument. Both parties have been allotted an equal amount of time for their argument. And so we're going to stop there, and I'll read the rest after we've heard from the attorneys. So for the state of Ohio,
thank you, Judge.
Mr. Baumel.
May it please the court, Mr. O'Brien, Mr. Grubb, ladies and gentlemen of the jury. When we met back with each and every one of you individually, early September, mid-September, we gave you a little bit of an education on the laws that pertain to the death penalty in the state of Ohio. And there you learned that Ohio has specific guidelines, specific rules for a jury to follow in determining the appropriate sentence, determine when the death sentence is appropriate. And as a representative of the state of Ohio, Ms. Schucke and myself, we truly appreciate the gravity of the decision that you're about to make. For each and every one of you are seated here today as jurors. We started with about 300 plus jurors. And the reason that we're down to 16 jurors at this point, 12 jurors who will go back and deliberate, is not only that each and every one of you committed to following the law, but that each and every one of you expressed an opinion that led us all to believe that you too truly appreciated and understood the gravity of the decision you're about to make. But when we talk to you individually, when we talk to you as a group, and as we've sat through these proceedings, we've all continued to commit to following the law. A willingness to commit what the law of the state of Ohio is, to weigh the evidence in accordance with those rules, and to come to a decision based upon the law. And you know that the law in the state of Ohio, it's not an eye for an eye. Every murder that's committed in the state of Ohio is not automatically that the death penalty is a potential punishment. Nor is the law that each and every one of you can guide how you want to go about evaluating this evidence or coming to a determination as to whether the death sentence is appropriate. The law is very specific and it gives you an objective standard to follow. And that is, if the aggravating circumstance outweigh the mitigating factors, and you are convinced of that by proof beyond a reasonable doubt, then you must return a verdict of death. If that is not your conclusion, then you have three life alternatives: to sentence the defendant to life without parole, or to sentence him to life with parole eligibility after 30 years or after 25 years. And in the trial phase, we presented evidence to prove to you beyond a reasonable doubt that Kenan Ivery committed the crime of aggravated murder. And we also presented to each and every one of you evidence beyond a reasonable doubt to prove the specification in this case, the aggravating circumstance in this case, that in committing that aggravated murder, it was part of a course of conduct in which the defendant purposely killed or attempted to kill two or more persons. And on November 16th of 2014, less than 1 year ago, the defendant made choices that day. He made choices. He chose to return to Papa Don's after being kicked out. He chose to arm himself with a loaded .40 caliber handgun. He chose to go into that bar and ultimately pull out that gun. And he chose to aim it straight ahead at point-blank range at three individuals standing in front of him: Justin Winebrenner, David O'Cady, and David Hudson. And the defendant, Kenan Ivery, chose to kill Justin Winebrenner. It was senseless, it's horrific, it's a tragedy. And only by...
Judge, objection, can we approach?
Not only did that act cause the life of Justin Winebrenner, but by the grace of God, by just sheer luck, the defendant failed in his attempt to kill those two other individuals. I talked to you yesterday about some of the exhibits that we were admitting for this portion of the trial, for the sentencing phase, and those are all pieces of evidence that you saw and heard about during the trial phase when witnesses testified. It's all pieces of evidence that you had during your deliberations when you went back in the jury room to determine the defendant's guilt. You had those exhibits then. But I don't want you at this point to just think, boy, you know, we've had these, we've seen these, we've heard about these, and push that envelope aside. What I'm asking you to do is that when you go back there and deliberate as to those specific exhibits that are relevant for this portion, is to look at each individual exhibit, to hold each individual exhibit, and to analyze each individual exhibit as it goes to the element of proving the aggravating circumstance and being symbolic of the defendant's conduct that day. For you will have slides, pictures from the video, from the surveillance video. 1:53:55, 1:53 a.m. and 55 seconds. And you will have slides showing the defendant, gun in his hand, facing Winebrenner, Kenan Ivery, and firing it, purposely causing the death. And you will know, and you will weigh in your minds that that is the moment when a life was lost. Look at each of those stills, analyze them, understand what they mean as it pertains to this specification. Look at the pictures of the clothing of the victims, of David Izo, his Ohio State jacket, which has bullet holes right by the chest. And weigh in your mind how close he came to death that day. Recall the testimony of David Mulcahy, that the bullet fired by that defendant went through his arm, his left arm, and then went through his abdomen as well. And when you think about that, weigh in your minds how close he came to death that day. And look at the picture of Justin Winebrenner, the lifeless picture of Justin Winebrenner at the medical examiner's office. Look at the two bullets that went through his body. Hold those bullets. Feel the steel. And know in your mind that it was the defendant who intended that result. In order to get that result. And that it is the defendant, Kenan Ivery, who is responsible for the death of Justin Winebrenner. And weigh in your minds that Justin Winebrenner is permanently removed from this earth because of the defendant's conduct that day. When we talk about the aggravating circumstances, those are all the items you put on that side of the scale. When you go through the weighing process, those are the pieces of evidence, the testimony you heard, and the exhibits that go on that side of the scale. On the other side of the scale, the mitigating factors. And you've heard evidence of that over the last 2 days. Yesterday, you heard primarily, entirely from relatives. They do care for him, and they do want to do what they can to help him in this situation. But ask yourself, when you review their testimony, is it bias that affected their memories and their testimony about what great of a father Kenan Ivery was to his boys? Especially in light of some of the evidence you heard when Kim Fisher was on the scene. Ask yourself, when you evaluate their testimony, did their bias affect their memory and their testimony in regards to what a peacemaker Kenan Ivery was? Especially in light of the testimony, the evidence presented during Kim Fisher's testimony. You heard from Kathleen Kovach today from the Ohio State Parole Board. The defense told you in opening that she was going to tell you that life means life. And a sentence of life without the eligibility of parole does in fact mean life. But that's not true for the other 2 sentences. There's some uncertainty involved in that. A sentence of 25 to life, those first 25 years might be certain. But I think you heard from her testimony that at that point, things change. That process begins. A process of hearing from the defendant, of gathering information from the prison, gathering information from the defendant's families, and also talking with the victims, having the victims involved in the process. And that even if the parole board at that point decides to reject the request for parole, it's not over. In fact, it can happen again anywhere between 1 and 10 years. The process starts again. Talk to the defendant. Contact the victim's family. Find out what's been going on in prison. And it goes on again and again and again. If you get to a point, and I stress, if you get to a point in your deliberation where you're deciding between one of those life sentences, compare that certainty versus that uncertainty. You also heard the testimony of Dr. John Fabian. I think he tried to come across as an unbiased witness, as someone who's just trying to provide objective information to help you in this decision-making process. But I submit to you that he's not unbiased at all, that he's a hired gun, that he's been doing this process for a long time, been involved in this, getting paid for it, and just going over some of the things that he has in his website. For example, that his objective is to reveal the defendant as a human being, humanizes the defendant, and separates his character and background from his crime. I submit to you that his website alone tells you that he's pitching it. He's a salesman and trying to provide a formula to clients out there that if you present me, I can prevent the death penalty, I can prevent life without parole. Because he presented the notion that the defendant suffers from post-traumatic stress disorder. And that notion comes from the explanation that Kenan Ivery was the victim in 3 different offenses, 2 robberies and a burglary involving a gun. And I asked him, well, when you hear information from the defendant, do you just take it at face value? And he clearly admitted, and he knew that he had to admit this, no. That this defendant has all the motive in the world to be untruthful, to not be credible, because they're going to be providing information to help their cause. And yet he took that information at face value. Because there's no documentation to support that they presented. Just the information provided from his brother that he went through this circumstance. Kenan's brother did die. He was murdered in December of 2011. But you know that even prior to that murder, this defendant was into guns and possessing deadly weapons, because almost a year earlier, in January 2011, he's possessing an Uzi submachine gun. And you will have a photograph of that machine gun. And this is way before his brother dies. This is way before he could be claiming that his brother's death is causing him PTSD. And it's not just any gun. It's an Uzi submachine gun, a weapon that can cause devastation in an instant. That tells you about the defendant's character. That tells you about the defendant's mindset, way before the tragedy of his brother. Dr. Fabian talked about the DSM-5 that he utilizes, and it's kind of a handbook, a psychologist handbook for mental illness. And he agreed, and he agreed with my questions, that in that handbook they give examples of the type of situations where PTSD occurs. Exposure to war as a combatant or civilian, being taken hostage. And I submit to you that there is nothing credible that you heard in his testimony or throughout these proceedings about Kenan Ivery's background which would convince you that he has suffered the kind of trauma that would be PTSD. The mitigation evidence you've heard the last 2 days, family members, friends, Captain Kovach and Dr. Fabian, that goes on the other side of the scale. And I submit to you, ladies and gentlemen, that if you follow the law, you go through the weighing process, there can be only one conclusion, and that is that the aggravating circumstance in this case outweighs the mitigating factors, the mitigating evidence that you heard, and that the proper punishment in this case is death. Thank you.
Thank you, Judge. Your job has not been easy. Last week, past couple of weeks during the trial, you saw autopsy photos. You saw videos that were disturbing to watch. You heard graphic testimony. Decisions. That was not easy. I hate to be the bearer of bad news, but it ain't going to get any easier for you. Because you guys are going to go back in that room, and you guys have the power of life or death. You do. Now, I will tell you that there was a judge that used to be down on the second floor who is now retired. And at the end of every trial, she used to say to the jurors that, except for being in the military, there are 2 boxes that the average citizen can use to keep the democracy going. There's the ballot box and there's the jury box. So we thank you for your service. Because as corny as it sounds, people like you keep the democracy going. Now, what I would say to you next is something that is crummy to say to another human being, but before you get offended, let me explain it, and you'll understand what I mean. You people are here because you are all average. And let me tell you what I mean by that. When we did individual voir dire back in the jury room, however long ago, we talked to all of you about your views on the death penalty. And not just you people, but every person that came after. And I will tell you that there were some potential jurors that would say, I read the article in the Beacon Journal, why do we need a trial? Can we just kill him now? And a little bit facetious, but really not too much. I mean, there were people who felt that. And every juror has a different jurors when it comes to the death penalty. I use a 1 to 5 system. And people who answered like that, they are ones in my system. And they never get a chance to get on the jury because clearly they could not be fair to Kenan Ivery. So either the judge kicks them off or we kick them off, but we get rid of those ones. And when we would talk to people back there, there were people that would say, I don't care if he blew up a bus full of kindergartners. I could never give the death penalty in a million years. Okay? Now, in my little scale, they're 5s. But I know that I'm never going to get a 5 on a jury because, again, there are people who say they could never give the death penalty, and they can't be fair to the state of Ohio. So they are removed. They are not sitting here. And the system is designed with the number of people that we can get rid of, to get rid of the 5s and the 1s, to get rid of the 2s and the 4s, and to end up with a bunch of 3s, which is why I say you're average. You may be outstanding in certain aspects of your life. You may be great chefs. You may be great checkers players. You may be great singers, whatever. But for our intents and purposes, you are here because you are the 3s for the most part. You are the people who told the judge and told us that you can follow the law. You told us that you understand that you do not have to give the death penalty. In fact, I will tell you that never does a conviction for aggravated murder ever automatically require the death penalty. But you also told the judge and the attorneys that you will consider the death penalty. And that is why you are here. You will consider the death penalty, you will consider the various life options, and you will make your determination as to what you think the appropriate sentence is. That's your final job as a member of this jury. You have to decide what is the appropriate sentence. You have 4 choices. And we're going to talk about it a little bit. First choice is life in prison. First choice is life in prison with parole eligibility after 25 years. And what that means is Kenan Ivery potentially can serve the rest of his life in prison. He will see the parole board in 25 years. But what you have to understand is your job is to sentence Kenan Ivery on the aggravated murder charge. You also convicted him of a couple of attempted murders, a couple of felonious assaults, weapons violations. By law, Judge McCarty will sentence him on those. And she has the ability to sentence on those and either run it consecutive or concurrent to the other number, the 25 to life. You are only sentencing him for the aggravated murder conviction. He will be sentenced on the other things that you convicted him of by the judge. Okay? Your other option is, the second option I should say is, life in prison with parole eligibility after 30 years. Again, he will see the parole board based just on the aggravated murder conviction after 30 years. Okay? He'll be 66 years old. But again, that does not take into account the sentences he could receive from the judge, the attempted murders and the felonious assaults, the weapons under disability, the carrying concealed weapon, and things like that. Third option is what we call, what you heard this morning, LWOP, life without parole. And that means just what it means. Ivery will walk into a prison, and when he comes out of that prison, he will be in a box. That is exactly what it means. Life without parole means he will never breathe air as a free man again. He will spend the rest of his natural life until he is dead in a cell about 2/3 as big as a council table with a metal bed and a metal sink and a metal toilet. That's what life without parole means. And then the fourth option that you have that you must consider, but is not automatic, is the death penalty. Like I told you before, things aren't going to get easier for you. You have the power, each and every one of you, to decide between life and death. Now, how do you do that? Well, you have to weigh the aggravating circumstances and the mitigating factors. Now, I want to talk about this a little bit because the judge has already read through the instructions, but there are some things in the instructions that I think are a little bit counterintuitive. Okay? So, for example, in this case, in the state of Ohio, Revised Code Section 292904, this is all the criminal laws in the state of Ohio, there are 10 possible aggravating circumstances. Okay? There are 10, they are listed by statute. There are 10 ways that somebody could be eligible for the death penalty.
Objection.
I'll overrule it with certain, leeway.
Well, what I would say is, Mr. Ivery has been convicted of you of one of those capital specifications. And you've heard from the judge, you've heard from the prosecutor. He was convicted of kill or attempt to kill 2 or more people. That is the aggravating circumstance. That's it. That is the only thing that you may consider as an aggravating circumstance. Now, the judge just read to you, and she said, the facts of the crime cannot be an aggravated circumstance. And again, that may seem counterintuitive to you. Well, you can't consider the facts of the crime. In your verdict last week, you found him guilty of prior calculation and design. But you cannot consider that as an aggravating circumstance. That is not an aggravating circumstance. There's one. Cause, kill or attempt to kill 2 or more people. That is the only thing that you can consider. You may not, you will not, you shall not consider any facts of that crime. And I know it sounds crazy, and I told you it's counterintuitive, but that's what the law says. You can't consider prior calculation and design. And when the prosecutor says it was tragic and heinous or whatever words he used, you can't consider those either. I don't care if you thought it was tragic or horrible or heinous or any other adjective that you can use. The law says you can't consider that. You can consider one thing. Kill or attempt to kill 2 or more people. That's it. That's all. It's the only aggravating circumstance that there is. Okay? No prior calculation design, no anything, no nothing, I can't, nothing else. That's it. That's the aggravating circumstance that you have to weigh. Now, you have to weigh that aggravating circumstance against mitigating factors. Mitigating factors is a little bit different. Now, the judge read you the jury instructions, and I'll talk about it in a second, some mitigating factors. But for mitigating factors, again, in the statute book, there is a catch-all. There is a and anything else that you may consider mitigating. So, what you must consider, what you must weigh, is you must weigh the fact that he killed or attempted to kill 2 or more people versus whatever else you think is mitigating. And the thing about mitigating factors are, what I think may be mitigating, you may not think are mitigating. And what you think are mitigating, you may not think are mitigating. And what you think are mitigating, you may not think are mitigating. We don't list them out in a statute like the aggravating circumstances. We say, ladies and gentlemen of the jury, we are trusting you to decide what makes this person over there worthy of life. What's important to you? We don't tell you what they have to be. But think about what we do. Think about the law. We say you have to take the aggravating circumstances and weigh them with the mitigating factors. Now, again, like I said, the mitigating factors do not have to be unanimous. So when I say we, I mean the law. I don't make the law, they don't make the law, she doesn't make the law, the legislature makes the law. What the law tells us is you have to weigh the aggravating circumstances and the mitigating factors. But we don't tell you how to weigh them. We don't. There is no point system. It's not like, well, this aggravating circumstance is worth 10 points, but this mitigating factor is worth 3, and if you add this one, it's worth 5. We don't do that. We don't tell you how to do that. We leave that up to you. We, again, when I say we, I mean the law. It's not us. But the law, frankly, doesn't tell you how to do that. You have to decide how to do that. Because what's important to you might be different than what's important to you, and what's important to you might be different than what's important to you. You, each one of you, individually, has to decide this case for yourself. This is different than in the trial phase. In the trial phase, in order to convict Kenan Ivery, you had to have a unanimous decision. Or in order to acquit Kenan Ivery, you would have had to have had a unanimous decision. That is not the case here today. One of you can say, if one of you says, I don't think the death penalty is appropriate, that's it. One of you has the power of life. Even if others of you think death is appropriate, one of you can stop it. So, you have to weigh the aggravating circumstances with the mitigating factors. And the aggravating circumstance, singular, because there's only one, with the mitigating factors, and like I said, we don't tell you how to do it. And when you think about it, you know what the aggravating circumstance is. I'm going to tell you what I think are some of the mitigating factors, but you may think differently. We're asking you to weigh like two separate things. It's like saying, what's more, 5 inches or 6 ounces? What? Well, that's kind of what it is. This is a difficult thing, but we leave it open to interpretation because it's so important. So, aggravating circumstances, mitigating factors. You have to weigh them. We do not tell you. The law does not tell you how you have to weigh them. So what you have to do is each and every one of you has to make your own individual, personal, moral decision as to does Kenan Ivery deserve to die or does he deserve to live? Each one of you has to make your own decision on that question because you do not need a unanimous jury. One of you can stop it. So you can go back there and you can deliberate and you can talk to some of the other people and you can hear what they have to say. But like the judge puts in the instructions, do not change your decision just to get out of here and make the other jurors happy or whatever. If you have a firmly held belief in a certain decision, hold on to that decision because that is the only way that the system works. The system calls for one person being able to stop it. So if you have in your heart, whichever way you think, hold tight to that decision. Aggravating, mitigating. What's mitigating in this case? Well, like I said, it may be different for everybody. But the judge just said, mitigating factors do not have to unanimous. Maybe you two think one, and you think one, and you think one. They do not have to be unanimous. You have to decide personally what's a mitigating factor. The judge listed some in her jury instructions on page 3. Whether it's unlikely the offense would have been committed but for the fact the defendant was under duress, coercion, or strong provocation. Well, think of a definition of duress. The defendant was compelled to act either by actual physical force or threatened physical force directed toward him. And then when you go to the top of page 5, whether a course of conduct placed the defendant under duress or coercion depends on the effect of the conduct upon the defendant, considering the defendant's age, sex, health, mental condition, and all the surrounding circumstances. Well, duress sounds an awful lot like self-defense. We are not claiming self-defense. You guys have already ruled on self-defense. There is no self-defense in this case. But you can consider duress, especially based on the testimony of Dr. Fabian. Because what did Dr. Fabian say? Remember, the jury instruction I just read you said, considering the defendant's age, sex, health, mental condition, and all the surrounding circumstances. So, Dr. Fabian, who prosecutor Bob Mel will tell you was a hired gun, and I will tell you he's one of the foremost neuropsychologists in the country, and you can decide. You heard his credentials, you heard what he does. Yeah, he gets paid. No kidding, so do I. I would think that all of you who have jobs probably expect to get paid too. But what whatever you think of Dr. Fabian, if Dr. Fabian was a hired gun, he would have done a whole lot better than that report. He would have said that Kenan Ivery is manic depressive, and he would have said he's schizophrenic, and he would have said he's mentally retarded, and he could have said all these things that probably would have made my job a lot easier. But like I asked him on redirect, he gave it to you all, warts and all. Okay? He told you alcohol dependence, cannabis dependence, antisocial disorder. We didn't hide Kim Fisher yesterday. We didn't hide Kenan Ivery back to his trial. We're telling you everything. But what Dr. Fabian said, last line of his report, you'll have it in evidence. It is my opinion within a reasonable degree of psychological certainty that mitigation evidence can be considered pertaining to a condition of PTSD due to prior trauma, which may have placed him at risk for heightened fight versus flight reaction, increased autonomic arousal, irritability, potential misperception of threat. So when you talk about duress, when the judge tells you that duress is actual physical force or threatened physical force directed towards him, and that Dr. Fabian tells you that for whatever reason, not for whatever reason, for the fact that he's been the victim of crime and that his brother was murdered, that he has this misperception of threat. So that goes into whether or not he was under duress at that time. Maybe it's not enough for self-defense, but his misperception because of his post-traumatic stress disorder to the threat that he thought was upon him is something that you must consider as something that we are asking you to consider as a mitigating factor. Now, the prosecutor talked about, well, maybe Kenan's just lying and he picked all the right questions and gave all the right answers. You heard Dr. Fabian talk about the validity of testing, that you can't do that. And if you do try to do that, they'll catch you. And frankly, I'm going to tell you right now, Kenan Ivery ain't smart enough to outsmart those tests that Dr. Fabian gives him. So, he suffers from post-traumatic stress disorder that impacts how he perceives threats. So that night you have to decide, was he under duress when that happened? Not self-defense, forget that. But was he under duress? It's a different standard. And I'm telling you he was. And I'm telling you that may be a mitigating factor to you. facts of the crime. Remember I told you, you may not consider the facts of the crime as an aggravating circumstance. Okay? Can. However, and the judge has read it to you, you can consider the facts of the crime as a mitigating factor. You've seen the crime. If there's something about seeing what happened that makes you think, maybe this case is not a death penalty case. If Kenan Ivery would have walked into that bar and just pulled out his gun and started shooting people, but this is different. The facts of this crime are a little bit different. So yeah, I'm going to find him guilty, but still, that mitigates on his behalf. Okay? He's not like the guy that walked into the movie theater in Colorado and killed 13 people and wounded 30, who, by the way, about a month ago was sentenced to life without parole.
Judge.
But that's...
Sustain. Disregard that, ladies and gentlemen.
We approach.
No? Keep going.
You may consider remorse. That can be a mitigating factor. Okay? You heard Kenan Ivery this morning. You heard him apologize. You also heard Kenan say that he wanted to write a letter to these people sitting over here ever since the first time he met Attorney O'Brien on November 18th or 19th. And I will tell you, as an officer of the court, he has asked me from the first time I've ever met him on December 5th or 8th or whatever it was, that he's wanted to write a letter to the Winebrenner family to apologize for what happened. So that remorse is not phony. When Kenan Ivery today said that comes from the heart, that comes from the heart. And the fact that he has remorse for what he did that night, you may consider that as a mitigating factor. That is another mitigating factor that you can add to this side of the ledger. The aggravating circumstance, when you think about it, takes up about, kill or attempt to kill 2 or more people, takes up about 10 seconds of Kenan Ivery's life. Kill or attempt to kill. It's from the time the gun fires, the guy, from the time the gun comes out to the bullets are fired. You've seen the videotape, you'll have it back or you can watch it again. It's about 10 or 15 seconds of Kenan Ivery's life. That's the aggravating circumstance. 10 seconds of a life of 36 years. And what I'm telling you is, as a mitigating factor, you can consider other things about Kenan Ivery's life. You can consider the fact that he got an education. That can be a mitigating factor. He has a high school degree, as does everybody in his family. He was not troubled in school. And you can consider that as a mitigating factor on behalf of Kenan Ivery. You can consider the fact that he has a ton of family support. Not the kind of support that says, oh, Kenan, you got framed, oh, boo-hoo, but the kind of family support that said, I don't care, we still love you, Kenan. You can consider that a mitigating factor. And frankly, we may disagree about this. You can consider as a mitigating factor whether or not Kenan Ivery was a good dad. You heard people talk about this. Now, here's what I'm going to tell you. The prosecutor stands up and he says, how can you be a good dad? The guy's dealing drugs. And we've never tried to hide that from you. But what I'm going to say to you is just because he's dealing drugs, that is not mutually exclusive from being a good dad. Okay? There is a certain subculture of society where people get arrested, they get convicted of a felony when they're 18 or 19 years old. They're stupid. I saw it when I was working at the prosecutor's office. I see it now as a criminal defense attorney, and they become convicted felons at 18. And it cuts down their possibilities in life. Okay? There's a lot of jobs they're not going to be able to get. And if they can't work, but they still support themselves, they get into more criminal activity. And then they get arrested again, maybe go to prison again, and they get out, and now they got another felony, so they can't get another job. And it's this wheel, and a lot of people are caught up in this wheel. And what I'm saying is, it doesn't, I'm not saying that his lifestyle was right for his lifestyle. I'm not saying it's appropriate, but I want you to think about him as a dad. Listen, we have a society now where, well, just saying, it's an epidemic. We got a lot of black fathers that don't give a rat's fat ass about their own kids. We don't. That's just the way it is. And we got a guy over here, his kids are good students. Why are they good students? Because he helps them with his homework. His kids are good athletes. Why are they good athletes? Because he helps them. His kids are respectful. You heard some of the people say how good his kids are. Why? Because he taught him to be that way. So yes, the prosecutor found out he dealt drugs, but do not say that he didn't care for his kids and he was not a good father and did not try to do the best he could, because he absolutely did. And those kids are good kids, and they're going to stay good kids regardless of what happens. And I'm going to ask you to at least give him the opportunity to maybe talk to his kids on the phone someday. That kind of segues into criminal record. You cannot consider Mr. Ivery's criminal record as an aggravating circumstance. You can't. Whether the drug convictions, the gun convictions, no. There is only one aggravating circumstance. I don't know how many times I have to say it, but it's so important that you understand it. You can't consider his record as an aggravating circumstance, but you can consider his lack of violent past record as a mitigating factor. Drug charges, yes. Weapon charge, yes. Assaults, no. Ag assaults, no. Felonious assaults, no. Ag robberies, no. Robberies, no. Ag burglaries, no. Burglaries, no. We went through a whole litany of things about Kenan's record. And the fact that he does not have any violence in his past, that you can use as a mitigating factor. And he doesn't, because if he did, you know that he would have been all over it yesterday. But he didn't, because it's not there. And that can be a mitigating factor. And it may be for you, and it may not be for you, or it may be for you, and it may not be for you. But that is why each one of you have to make your own personal decision about this. You know, the death penalty, whether on my little 1 to 5 scale, you're a 1 or a 2 or a 3 or a 4 or a 5, you know, I think we would all agree that in order for the death penalty to be effective, it has to be reserved for the worst of the worst. You can't just throw it out there willy-nilly. It truly, and he used the word this morning to say he's not a monster. Monsters deserve the death penalty. You've seen what he did that night. You've convicted him of that. You've heard other aspects of his life. Is the death penalty appropriate in this case? Ultimately, you make that decision. But I'm telling you, the death penalty should be for the worst of the worst. And I don't think under any stretch of the imagination you could say that he is the worst of the worst. And then finally, you have the ability to say, I don't want to be part of the taking of another human life. prior calculation and design? Go think about it. Go in the back room, talk about it, think about it. Go to a hotel tonight, sleep on it. Come back tomorrow, think about it some more. You know, when you watch the news, well, that's a terrible thing to say because you guys haven't been able to watch the news for the past month or so. But when this trial is over and you turn on the Cleveland News, and the first 5 stories are good guy kills bad guy kills good guy, man kills woman, woman kills man, man kills kid. Jesus. It's just death and death and death all the time. And as a society, we're just immune to it. Death. And I'm telling you that murder is wrong. Murder, if it's committed at the doorway of Papa Don's pub, is wrong. But murder, even if it's sanctioned by the state, doesn't make it any less wrong.
Objection.
Well, I'll sustain that. It is the law of the state of Ohio, so you do have to follow your oath and follow the law as you find the facts to apply to that law. So.
I'm sorry, you said it's the law of the state of Ohio?
I said that the death penalty is part of the law of the state of Ohio. So, yeah.
Absolutely. The death penalty is the law of the state of Ohio. Frankly, that doesn't change what I just said. You each have the ability to say, I'm not going to take part in the death of another human being because human life has dignity. Everybody's does. Now, you will have the ability to punish Mr. Ivery. Okay? Like I said, there are no slaps on the wrist. He's going to live in a cell half as big as this table for as long as you want him to be there. And I'm telling you that that is the appropriate punishment in this case. Mr. Ivery does not deserve to die. And I will ask you, when you come back with your verdict, to come back with one of the life sentences. When you do that weighing, and you each have to do it for yourself, when you do that weighing, and you weigh all those mitigating factors, and I want you to think about things that I haven't said, because there's no exhaustive list, but when you do that weighing, the aggravating circumstances do not outweigh the mitigating factors in this case. And if that's the case, the appropriate sentence and the appropriate punishment given by you is one of the life sentences. And on behalf of Mr. O'Brien and on behalf of Kenan Ivery, I ask you to show mercy and give him one of those sentences. Thank you.
Ladies and gentlemen of the jury, I will go back to Mr. Brevin's scoring system, 1 through 5. And you can even, you each and every one of you know the process that we went through in individual voir dire. We went through 300 jurors individually, not only to tell you about the death penalty, but to do everything we could possibly do to end up with 12 people who would follow the law. That's why we spent days and days, and that's why these trials, as opposed to other trials in this courthouse, this trials last for months. And one of the reasons is that when we got to this point, for everybody here to have faith in the system, is that 12 jurors are going to follow the law. This is not the time to pass the buck. We've gone too far. You've all committed too much to follow what the defense attorney is telling you and say, but the death penalty is wrong. Do what you want to do. I'm not going to ask you to pass the buck here. I'm not going to ask you to rely, well, the judge will do something about all those other crimes. Don't worry about it. I'm not going to ask you, hey, the parole board, they might let him out. They might not let him out. That's their job. This is not the time to pass the buck. I'm not going to tell you what to do, but I am going to ask you as strong as I can, follow the law here, ladies and gentlemen. That's what that scoring system was all about. Being a prosecutor, being a representative of the state of Ohio, that occurred here, that's not my job. My job is to present the evidence to you for you all to make the decision and to make that decision in accordance with the law and not to pass the buck here. And we will respect whatever decision you make. But we will not respect it if you do it because you ignore the law or you ignore your duties here. You will have the instructions. And I don't want there to be any confusion when Mr. Grevin says you cannot consider the crime here. You cannot consider the circumstances of the crime. So prior calculation and design, off the table. I agree. But you're told specifically in the evidence section you are to consider only that evidence admitted in the trial phase that is relevant to the aggravating circumstance of which the defendant has been found guilty. So you can consider that moment in time, which you will have pictures, when that defendant pointed that gun at Justin Winebrenner and took his life. And it is your duty to consider that. And it is your duty to weigh that. And you heard about mitigating evidence, but just because you heard it, that's not the end of the story. You all might have different opinions as to what is mitigating and how much weight there is, but and Mr. Grevin said, but how do you do that? Well, this is how you do it. You deliberate with each other. You just don't go back into that jury room, take a vote, and then it's over with. You deliberate with one another like you did the first time to decide how much weight to give all these pieces of evidence. If one juror brings up about Israel Rory, one of the defense witnesses, the individual is a Marine, a banker, attends Stark State for electrical engineering, and he told you, Kenan Ivery is a better dad than me. Now that'd be mitigating evidence. That'd be a mitigating factor that could be important for you. And maybe that is important to one of you. But I would hope you would deliberate because maybe another juror would bring up, well, is he a better dad than him? Because now we know that not only did the defendant engage in dealing drugs, having drugs and drug paraphernalia around the house, but this defendant had loaded guns in the house. One of them being this Uzi submachine gun loaded with 28 rounds just sitting in the dresser in the bedroom. That these kids had to go to prison to visit their dad. Now, I don't know what kind of dad Israel Rory is, but I think that's the type of information you would want to discuss among each other and decide how much, if any, weight to give that. Not just to automatically say because Mr. Grevin yelled at you, he's a good father, he cares. Because to tell you the truth, none of us were involved with these individuals' lives. We're brought into this because of this crime. We're newcomers, just like you. So you don't decide the case based on us trying to tell you what the evidence is or what the law is. You decide this case based upon the testimony you heard from that witness stand and the law and the pieces of paper in front of you. And when you decide to give how much weight to Dr. Fabian's testimony of the PTSD, that was a mental condition at the time, well, read that report. And also consider what he put in his report about another part of his mental condition. It was interesting that the testing found grandiosity, and I pointed out some of the definitions of that. Quote, unrealistic sense of superiority, quote, a sustained view of oneself is better than the others. That's not to us. So you go back and you deliberate what you think makes sense as far as the motive of Kenan Ivery that day. And recall, back on September 28th, when we gave you an opening statement, and we told you based on the evidence right away the theme of the case, that it wasn't because of PTSD that he did this, but it was because he'd been disrespected. It was way before Dr. Fabian issued his report last Friday, talking about grandiosity. So how do you do this? You deliberate and you weigh the evidence. You weigh the aggravating circumstance. You weigh the mitigating factors. Don't accept anything blindly. And yes, it's for each and every one of you to make your individual decisions, and we respect that. But that does not prevent you from talking with one another, listening to each other's point of view, and making a decision based upon the 12 of you discussing how much weight to give these things. Mr. Grevin attacked my use of descriptive words of this purposeful killing. I've tried to come up with words such as senseless, tragic, trying to quantify.
Same.
Overruled. Let's let him finish his thought. Overruled.
I've tried to come up with words to quantify this purposeful killing. That's what you're asked to do. You're asked to quantify the purposeful killing of Justin Winebrenner. I'll throw those words out because none of them are sufficient. None of them adequately tell you the amount of weight that should be given to that aggravated circumstance. None of them are good enough. The purposeful killing of Justin Winebrenner, the amount of weight to be given that is enormous. It is significant and it is enormous. And that is going to be part of your deliberations. And with full appreciating and understanding to the gravity of your decision, and with full understanding and appreciation of the gravity of my request, I ask you to follow the law, evaluate the evidence, and return a verdict of death in this case. Thank you.
All right, ladies and gentlemen, we're going to go back to those instructions where we stopped, and I'm going to finish reading those to you. It's on page 11 under the word verdicts. You will have 4 verdict forms in your possession during your deliberations in the jury room. I'm going to read these 4 verdict forms in precisely the same order as my previous instructions were presented to you. You are not to make any inference from the order in which I read these forms to you. There's 4 forms. You will only fill out 1 form. All right? The first form says life imprisonment without parole for 25 years. And there's actually not a spot for you to write a word in here. There's 4 separate findings. You decide which one applies, and that's the one you would sign, okay? So it's a little different from the verdict forms in the original trial. So under this particular verdict form, it says, we, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing related to count 1 of the indictment do not outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of life imprisonment without parole eligibility for 25 full years should be imposed upon Kenan D. Ivery. And then it asks you to fill in the date, and it has to be signed by 12 jurors. So that's the first form. The second form says life imprisonment without parole for 30 years. The language is basically the same, except for it's making a separate finding on the term of sentence that you're recommending. And then the third one is life imprisonment without possibility of parole. It's the same finding, which is that the aggravating circumstance does not outweigh the mitigating factors, and you are recommending a different term. In this one, it would be life imprisonment without the possibility of parole. And then in the final verdict form, the language is a little bit different, and it says, we, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstance that the defendant was found guilty of committing related to count 1 does outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon Kenan Ivery. It asks for the date and the 12 signatures. So you will have those 4 forms with you, and as I indicated, you would only return a verdict on 1 of those forms. To render a verdict, all 12 jurors must agree and sign the particular verdict form. When all 12 jurors agree upon a verdict, all 12 jurors will sign the appropriate verdict form in ink and inform the bailiff. The bailiff will then return you to the courtroom. Should you be unable to reach a verdict after complete and full deliberations, you shall advise the court accordingly in writing. You will then receive further instructions from the court. The foreman, whom you previously selected, may continue in that capacity, or you may elect someone entirely different for this phase of the proceedings. The foreman will make sure that your discussions are orderly and that each juror has an opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreman is the same as that of any other juror. The foreman will read the verdict in open court. Your initial conduct upon entering the jury room is a matter of some importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your opinion even if you decide that you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourselves, but you should do so only after a discussion and consideration of the entire case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender honest convictions or beliefs in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. If during your deliberations you have a question, it should be discussed in the privacy of your jury room. No question should reflect the status of your deliberations. Any question should be put into writing and then delivered to the bailiff, who will submit it to the court. I will place into your possession the exhibits and the 4 verdict forms. The foreman will retain possession of the exhibits and the verdict forms and will return them to the courtroom when you have reached a verdict. These are the only exhibits that you may consider. Until your verdict has been announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Deliberation should take place only when all 12 jurors are in the jury deliberation room together. Should any one juror absent himself or herself at any time, all deliberations must cease until all 12 jurors are together in the jury deliberating room. Those of you selected as alternate jurors to serve on this jury panel must remain and be sequestered until the jury has returned its verdict in open court. A juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the deliberating jurors is found by the court to be unable or disqualified to perform his or her duties. You will be taken to a location apart from the other jurors and will remain under the direction of the bailiff until the verdict is reached. The alternate jurors will not accompany the jury to the jury room or participate in deliberations unless directed by the court. The alternate jurors continue to be a part of the jury panel while the other jurors are deliberating and until you are fully released from this case by the court. You shall not discuss this case with anyone or each other or tell anyone how you would have voted until you are fully released from this case by the court. And you are now being sequestered during your deliberations in the sentencing phase of this case. It is impossible for the court to determine the length of time that your deliberations will take. Take that time which you believe to be appropriate to thoroughly and carefully review all of the evidence and other information provided to you. The rules to be followed during this sequestration will be identical to the rules which were followed by you during the trial phase of this case. And so we are now going to allow you to go back to the jury room, and you want to either affirm your original selection of foreman or just basically have that discussion and confirm that or select a new one, and then we will have you ring the bell then, because I'm assuming you may want to take a brief break, okay? But we're going to ask the 4 alternates to stay here for the moment, okay? And Ruth will be called up. So actually, Shay will probably have you step back into the chambers areas with you. So we'll just go ahead and have you all step out, okay? The other thing I just wanted to indicate, I don't know if Shay took the court's general view of this, because we are impeding on a weekend, is that the court's wish is that we would deliberate later into the evening. I'm not going to tell you when to stop. We're going to go till at least 9 o'clock, so I'm kind of giving you the heads up on that now. We'll obviously have you break for dinner, but that's the court's anticipation, so that you can get some full amount of time in here tonight before, if you were to go to the hotel, before you'd have to start up again tomorrow morning. Okay? All rise. ask the parties that are interested in knowing what the status of the case is. If you're affiliated with the prosecution, make sure that they are aware of how to reach you. The same for those that are affiliated with the defendant. And if you're not otherwise affiliated with one of the parties, if you wish us to. All right, thanks.
Hey, Judge.
Yes? You want to put something on the record?
Yeah.
Okay, that's fine.
I
It's
was
just,
wondering out here, basically the prompt or something over
we
there.
can do it at sidebar.
Buried about 100 yards further out. The smell of the buried rapidly. A problem with the kids' favorite stuff. My plan was to try and argue how these people did not deserve the death penalty. There has to be some kind of proportionality. These people did not deserve it. Kenan Ivery clearly did not deserve it. I think by the court's sustaining of the objection to the counter-round theater, probably not going to let me go there, so I want to be proper with that as well. A little bit more start. Yes, and that's no.